So my structure will be threefold. I'll very briefly introduce why we need to reform the way we teach legal education to incorporate climate change issues. I'll then deal with the three areas that I suggest that we need to reform: the substantive law, the adjective law, and the legal practice areas of the curriculum. Now, the typical legal curriculum involves what is known as the Priestley 11 areas of academic knowledge. Now, they can be grouped in three areas. First, 8 of those courses concern substantive law topics. 3 concern adjective law topics, and I'll explain what I mean by adjective law in a moment. And 2 concern the practice of law. What we can see when we look at those 11 courses, that they're content-based. They focus on topics of knowledge and doctrines of knowledge. Now, this requirement to teach the Priestley 11 results in an orientation of legal experience towards a content-based experience rather than a practical experience. Now, of course, the Priestley 11 does develop some practical skills, but they're orientated towards resolving the conventional legal problems that arise in areas of substantive law. But those problems are really what Liz Fisher refers to as the hot situations. And the problems that climate change causes are classically hot situations. Liz Fisher defines the hot situations as being involving complex, polycentric, interdisciplinary, uncertain, and changing problems. The consequence is that students are less equipped when they finish law school to understand how the legal tools of substantive law and adjective law can be used in the practice of law to deal with the problems caused by climate change. And I'll suggest students are even less equipped to be climate conscious when they begin their own practice of law. So that suggests that we need reform in 3 areas. First, to mainstream climate change in the law curriculum. Secondly, to study in greater depth adjective law and the practice of law, and not just substantive law. And thirdly, to integrate adjective law and the practice of law into the study of the substantive law. And so these are the 3 areas that I suggest there needs to be reform: the substantive law, the adjective law, and the practice of law. Let me start with substantive law. Now, you're familiar with the Priestley 11 areas of academic excellence, and 8 of those concern substantive law, and I've listed those on the screen. What we're doing when we're teaching substantive law is we're teaching the concepts and rules of law that define and frame the different bodies that make up the substantive law. But instruction on those concepts and rules of law will be assisted by instructing the students on the circumstances and the society in which those concepts and rules of law are developed. Because law is responsive to societal influences, and that includes societal values and the economic, social, and environmental conditions that are prevailing at the time and place. So students need to understand this responsiveness of the law and how the law needs to continue to adapt to changing societal influences. Coming back to the hot situations, we need hot law to deal with and address those hot situations. So this suggests we need to integrate the problems such as climate change within substantive law. And Galloway and Graham suggest that climate change can provide a thematic lens, an opportunity to explore all these different domains of law, both their culpability and their promise, and their limitations and scope. Now, by culpability, we're looking at the role that law as an institution plays in contributing to the problem of climate change. As far as law's promise is concerned, we're looking at the power of law to supply solutions to the problem of climate change. Now, when we come to integrate climate change in the substantive law, we need to be selective as to the materials that we are going to include. Now, that's true generally because there is so much to cover in so little time in each substantive law course that we do need to be selective in the cases that we include, the course materials such as academic articles and other readings in the course materials. But that also gives us an opportunity because we can include materials that are relevant to the climate change problem. And so, although that there is a difficulty in being selective, it also presents an opportunity. Now, a number of academics are doing wonderful work in developing toolkits for each of the substantive law courses to make life easy for the teachers of these substantive law courses. Nicole Graham and Julia Deem, amongst others, have prepared and are preparing toolkits which can provide that needed instruction in the types of materials that could be included in the course materials for the substantive law courses. I don't want to spend the time I have now in running through that. I just simply want to flag some ideas that can be included. So if we started with the climate change cases that could be included. So in courses on administrative law, we could include cases dealing with judicial review and merits review of administrative decisions which raise climate change issues. For constitutional law, there are many cases that are being raised, particularly in relation to human rights and other constitutional rights. So the right to life, but also the right to a clean and healthy environment is emerging, and there's many cases around the world which include that. In relation to company law, there's a growing number of cases dealing with not only with the duties of corporations, but also of the directors of those corporations to manage and disclose climate-related risks for the corporation. For tort law, particularly in the United States, there's been many cases brought in the traditional torts, negligence, nuisance, etc. But that also has emerged in other countries such as the Netherlands, New Zealand, and Australia. But moving away from the cases, the judicial decisions that we could include, there's also a burgeoning area of academic literature. And that involves practical legal scholarship because the literature is of use to a particular audience, the practicing lawyers and the judges who are having to decide this climate litigation that I've been talking about. And so that is materials that can be included in the toolkit. And we should also think outside the traditional areas of case law and articles to include explanatory materials, because again, there is a wealth of explanatory materials that are available that can instruct in the fundamental concepts and rules and principles of law in the area of substantive law. Let me now move to adjective law. Now, I said I'd explain what I mean. It concerns the regulation of the work of the courts, the business procedure by which courts go about their business of resolving disputes. So the adjective law courses would include civil dispute resolution, one of the Priestley 11 courses, evidence, another one, and also remedies for breaches of substantive law, which may be taught amongst as one of the topics within the areas of substantive law. Now, Carl Llewellyn, one of the American legal realists in the last century, said that adjective law is increasingly being seen to be inferior to substantive law. And he says that has a consequence. But he says it's important to recognize that adjective law is the way in which substantive law is made real. In his words, he says, the regulations of adjective law are the door to make real what is laid down by substantive law. Procedural regulations enter into and condition all of substantive laws becoming actual when there is a dispute. And he urges the law schools to recognize that the importance of teaching adjective law as an integral part of substantive law. So, what materials could we include on adjective law? Well, starting with the area of procedural law. Well, climate litigation has exposed a rich vein of adjective law, which can be useful in teaching adjective law. There are many climate change cases which are testing the procedural barriers to litigation, such as rules of standing to sue and justiciability. There's also climate change cases are testing the rules of evidence. And particularly this is true in relation to evidence of causation between administrative decisions and impacts of climate change, or between a proposed project and climate change, or between activities of corporations and climate change induced events. And thirdly, climate change litigation has prompted innovation in remedies. This logically follows from the fact that the hot situations demand hot law that evolves and adapts to these new situations. And that includes not only the area of substantive law, but the remedies for any breach of that substantive law. And so there have been many cases that have expanded the remedies that courts have ordered in order to remedy the breach of the substantive law. That brings me to my third area, which is the reform of legal practice teaching. Now, as I opened, I said the Priestley 11 academic areas of knowledge focus on substantive law and adjective law, not so much the practice of law, but they are also content-based. Now, there are two areas where we do see some teaching in the practice of law in the Priestley 11, the topic on civil dispute resolution and the topic on ethics and professional responsibility. But the problem for the teachers is that the demands of the Priestley 11 for content-based teaching leaves little time for the teaching of practice-based instruction. And that causes a difficulty. Again, returning to Carl Llewellyn, he says that the idea that has been propagated by law schools, here referring last century into the United States, is that the essence of our craft as a lawyer lies in our knowledge of the law. He says knowledge of the law is needed, but it is merely the precondition of our work as lawyers. So he notes that this idea that our craft lies simply in our knowledge of the law comes at a price. It means that the law students that come out of law school know nothing but the law, the legal tools, but not the simplest smattering of how to lawyer, how to use those legal tools. So he suggests that law education needs to go beyond teaching mere knowledge of the law to teach the craft of doing and getting things done with the law. Now, Llewellyn refers to law jobs, and one of his law jobs is the ways of handing the legal tools, the substantive and adjective law, to law job ends. And law job ends include providing advice to clients and the courts adjudicating disputes. So he suggests that the craft of how to lawyer is especially important. And in the climate change context, it is, of course, particularly important. The ever-changing problems that climate change produces demands an ever-changing law. And that means the lawyer students, if they have to practice the law, need to understand how do they adapt the substantive law and adjective law to address these ever-changing problems. So I suggest that one of the crafts of how to lawyer is how to think like a lawyer. And that is taught at law school. But I want to suggest that we need to go further in teaching that craft of how to think like a lawyer to deal with these ever-changing problems that climate change, amongst other hot situations, demands. My first way of thinking like a lawyer that I suggest needs to be taught is instruction in the forms and techniques of legal reasoning. Now, that is taught often in an introductory course, such as Foundations of Law, one of the Priestley 11 courses, but it's normally only taught over 1 or 2 weeks. So we need to revisit what it means to legally reason in providing advice and adjudicating cases, and to adapt that to the particular problems. As I said, the environmental problems and hot situations like climate change call for using the same forms of legal reasoning, but in different ways. And we need to instruct on that. So we need to adapt the legal reasoning for those environmental problems. The second way of thinking that I suggest needs to be taught is it concerns legal imagination. And Liz Fisher refers to it as being necessary because the abstract language of legal concepts needs to be applied to specific situations. And the legal concepts, they're the principles in the area of substantive law or adjective law, they have to be adapted to the specific circumstances that these hot situations give rise to. So these are just some of the questions that could be taught, and the students encouraged to use their legal imagination. So asking whether the current law in any particular area of substantive law is part of the problem or part of the solution. If it is part of the solution, is it currently adequate and applicable to deal with the problems that we have today? Is it, in a sense, fit for purpose? If it's not, how can it be developed? And in what ways? And so this requires instruction about thinking about the purpose of the law and the specific situations. The third way of thinking that I suggest needs to be taught is interdisciplinary thinking. Now, the whole structure is that we're trying to work at all the Priestley 11 courses and integrate climate change consciousness and how to deal with climate change issues into those areas. That itself involves interdisciplinary thinking across the boundaries of substantive law areas. But we need to actually encourage that, because often the solution is not simply in contract, in tort, in public law. It's across all of these areas that we need to be thinking. And then we need to be thinking outside the discipline of law in other disciplines. The sciences, for example, natural sciences, social sciences, political sciences, economics. And we need to instruct these students to think in those areas. They don't need to have expertise, but they do need to have a literacy, a working knowledge of what those disciplines are and how they are relevant to solving the environmental problems, the hot situations that arise. We also need to think across boundaries of jurisdictions. So in a federation such as Australia, we need to think across the states and territory boundaries. We need to think between federal and state boundaries. But we also need to think across the country's boundaries to look at what other countries' laws are, what the litigation there is, what are the judicial decisions in those jurisdictions. And of course, we need to thinking about what's happening at the international level. It's also a recognition that because of the interrelatedness and cross-boundary nature of the problems that are these hot situations, such as climate change, we need to understand how the law is dealing with those problems in different jurisdictions so that we can learn from that, and the litigation that happens elsewhere, we can learn from that as well. And my final way that I suggest that we need to instruct is how to think and act ethically. Now, climate change raises equity and ethical issues. It affects different people differently. It raises issues of distributive justice, procedural justice, and recognition justice. So as lawyers, we need to be conscious of these equity and justice issues. We need to be conscious of how climate changes causes injustice. Now, I've suggested elsewhere that this involves climate conscious lawyering. And I've suggested 5 ways, which I'm only going to outline, in which we need to instruct the law students of today who are the practitioners of tomorrow in climate conscious lawyering. The first is the need to provide holistic legal advice, not just dealing with a particular legal problem, but also other aspects of the problem so that the client can see the ramifications. We need to instruct clients about the climate change consequences of different courses of action. We need to instruct them on the ethical issues that are raised by climate change. Because although we have a professional duty under our various rules, we also have a duty because of the nature of the lawyers, the law as a profession. And so we need to think about the ethical issues that arise. We also need to instruct in the concept of responsible lawyering. This involves focusing on the lawyer's role as an officer of the court and a guardian of the legal system. That we should advise and act in our legal practice in ways that discharge our duties to the legal system and to uphold and advance the fundamental values and integrity of the legal system, including all aspects of justice, but particularly climate justice. And we need to integrate our ethical thinking and actions in our personal day-to-day legal practice. And so we need to give education at the law school about climate conscious lawyering. We should not leave that until the law students leave and start their practice of law. We need to begin the journey towards ethical and climate conscious lawyering at law school. Now, that's about thinking, but of course, thoughts need to be communicated. So we also need, in the practice of law, to teach how to communicate both orally and in writing. And to some extent, the courses do develop oral communication skills, but we need to develop those skills that are tailored to the particular practice of law and the practice of law that would involve climate conscious lawyering. And we need to develop written communication skills, not just the ones of writing an essay or a written exam or answering a hypothetical problem. They're involving written communication skills, but it's the particular skills involved in drafting advice, drafting pleadings, drafting submissions in court. Those particular skills need to be developed. Now, some of those written and oral communication skills can be developed through clinical legal education. So 2 universities in New South Wales, and Macquarie University and University of New South Wales, run a clinical legal practice course at the Land and Environment Court. So that concludes what I wish to say today. Hopefully some of those ideas that I've raised give you food for thought as to the ways in which we can integrate or mainstream climate change into the legal education course. So thank you, and I wish you well for the conference.